I think it's
Oh.
Caroline.
Is Caroline, have you had a message?
I think so. What do you think?
My opposition had 17 minutes.
You're going to go?
It's at 4 o'clock, so it's...
Order. Can please, colleagues please leave room quickly? We should have started already. Order. I call Emma Foody to move the motion, and I will then call the Minister to respond. There will not be an opportunity for the member in charge to wind up, as is the convention, 30-minute debates. Order. Emma Foody to move the motion.
Thank you. I beg to move that this House is considered a state adoption in the North East. Thank you for the honour to serve under your chairship. I'm grateful to have this opportunity to move the motion, one of considerable importance for my constituency of Cramlington and Killingworth. Mine's a newly formed constituency made up of the new towns as well as a number of villages. It covers the north of Newcastle, southeast of Northumberland and north and northwest of North Tyneside. Being on the edge of different local authorities means that over the last 10 to 15 years, our villages and towns have grown with significant levels of development. These developments have provided important and needed homes for our communities. However, there has also been significant challenges that these communities have faced, and adoption and delivery of infrastructure is key amongst them. With the commitment of the new Labour government to delivering the homes that our country needs, we need to ensure that we are not only building homes, but sustainable communities with the buy-in from residents, and delivering timely and appropriate infrastructure is a key part of that. Because a home is not just the property that we live in, but the street that we are on and the community that we are a part of. Yet for too many of my constituents, there are unacceptable delays in the delivery of even the most basic of infrastructure. Residents who have worked hard, saved and bought their first home, their family home or their dream home are left without adequate road surfaces, pavements, street lighting, pedestrian crossings and road markings. And too often, people are left in limbo, passed from one organisation to the next, with each one trying to pass the buck, whilst paying management fees, council tax, yet not having the basics such as completed pavements, roads or communal facilities. Residents are left frustrated and angry with a lack of communication from those responsible, a lack of accountability and no certainty on when these estates will be finished.
Can she give way?
I will give way.
I thank the Honourable Lady for giving way, and the situation that she describes in her constituency is mirrored in mine, so it's an issue that affects properties around the country. Locals in my own constituency will know the old Bird's Eye site. It was a brilliant idea to bring new housing into the town centre on a brownfield site, but have latterly discovered that the estate is half finished, that the roads are unpassable, that the paths are unusable. Does she agree with me that local authorities should be given additional powers, that there should be caps to the amount of costs that local authorities are required to pay to force developers to complete these estates so that people can live in their dream homes?
I thank my honourable friend for the intervention that she's made, and I think it is an experience that is shared around the country, and I think we need to look at all available options as to how we resolve this matter. Because, as we say, we're not talking about months that residents are left in this situation, but years. 5, 10, 15 years, families seeing their children growing up and leaving home before a road is even completed. And ahead of this debate, I asked my constituents for their testimonies and experiences of the range of issues that they've faced. Take, for example, David, who lives on the Fairways estate in the west of Cramlington. He speaks of roads and pavements on the estate that are largely untarmacked. It's made using bikes, wheelchairs, pushchairs, dangerous outside the home. And he talks of how they are cut off from other facilities, such as shops, schools and parks, because the necessary footpaths were not built for years. He says that only after constant resident pressure did the developer build a footpath. The footpath is unlit and poorly laid. You'd have difficulty using a pushchair or a wheelchair on it, and it links one housing estate to another through a field. And if you do have a car, the roads aren't much better, often unfinished, with higher risk of damaging your vehicle, or when the roads are icy, more risk of traffic accidents. Another constituent, Ian, highlighted how in 5 Mile Park in Wide Open, he's been contacting the developer for 3 years regarding the road surface. The estate was constructed almost 10 years ago, and he's been given excuse after excuse about why work has been delayed on the road, pavements and footpaths. And the developer informed Ian that the road had been completed more than a year ago. But poor quality work by contractors means it has not been brought up to adoptable standards. This is just one case of many where a developer will claim to have completed roads, pavements or other infrastructure, but not up to a standard whereby the local authority can adopt them.
Would my honourable friend give way on that point?
I'll give way, yes.
Thank you. I thank honourable friend for giving way. This is such an important debate, and likewise in my constituency in North Northumberland, in Amble, I have residents who are contacting me about a private developer who has left their estate in a scruffy and untidy manner and are using a sort of contractual error to try and escape blame. That's all in the context as well as we've seen planning spending go down by about 65% in the north of England. So there's a key issue about the resources that local authorities need as well. So would my honourable friend agree with me that private developers should be willing to bring up estates to an acceptable standard so that local authorities are not forced to adopt unkempt and unfinished estates?
I thank my honourable friend for the issues that he's raised. I know it's an issue that's raised with all of the MPs in Northumberland, and I absolutely agree with him that we need to look at all mechanisms to make sure that these estates are at an adoptable standard. As I was saying, from those in my constituency, Dan from West Meadows, another estate, shared how he worries that the delivery of local football pitches won't ever actually be brought up to the standard that has been promised. And Mark, who lives in Backwith View, told me how the street lighting on his road has never been switched on in the 5 years that he has been living there, yet he's paying full council tax and management fees. And many residents expressed their frustration that they are paying both estate management fees and council tax, yet because the estate is unadopted, they have poorer quality infrastructure despite paying more. And local authorities are often feeling the brunt of the complaints from residents, but hold actually little power to compel developers to bring private unadopted estates to the standards required for them to be adopted. And local authorities shouldn't be footing the bill for delays and lack of delivery from private house builders. Too often, local authorities feel hamstrung, left fielding complaints from residents when developers have long since left the site with little power to be able to compel any action. A chief planning officer at a local authority expressed to me that the current system is skewed towards developers. They pick their own contractors, timeframes and materials, often not up to the standard where a council would actually be able to adopt them. Yet it's the local authority left with understandably frustrated residents long after the developer has gone. So far, I will give way.
On this issue, thank you, Chair. On this issue of holding developers to account, I've seen this also in my constituency in Stockton North, where we have estates such as Willowsage Court, Wynyard and Queensgate, with unfinished roads, lack of facilities and high maintenance charges being paid. The Competition and Markets Authority said in a report earlier this year that there was an increasing trend to this type of estate, and they've recommended a set of national standards. I wonder if my right honourable friend would agree that we should have a national framework of standards for private developers, but also sanctions that can be put in place when the developers don't deliver.
Thank you for that contribution from my right honourable friend. In many ways, it's as if he's seen ahead in my speech as to some of the things I'm going to reference with regards to the CMA. So if I may, I will progress and make reference to many of the important issues which he has raised. So far, I've mentioned the homeowners, the local authorities and the developers, but there's another third party that has an important role, the utilities and the broadband companies who have to deliver the infrastructure as well. And in Erston View, residents remain on an unadopted estate as the developer and the water company have been unable to resolve adoption. A resident on the estate, Jim, feels that the water company and the developer have passed the buck back and forth, and yet there continues to be nothing done on the issue. As he put it, they are left in a stalemate. Often, it is the relationships between developers and utilities companies that hold back the full adoption of water mains and other utilities. The knock-on consequence meaning that roads that are left open and untarmacked whilst these disputes are ongoing. And whilst these issues between the developers, third parties, local authorities are all haggled over, it's residents who are left picking up the cost through estate management fees. This fee is meant to support a contractor whilst they carry out work on the estates, but residents have shared their experiences of being left unsatisfied by the system of estate management fees, which are often unpredictable, opaque and confusing. Many argue they are being ripped off, with fees being able to increase at unlimited and unspecified amounts each year. And residents like Oliver fear that if fees continue to go up, he would be unable to sell this property if he was unable to meet the fees. The Competition and Markets Authority's report earlier this year sets out that one of the things that creates the most distress for homeowners on these estates is the disproportionate response time that is taken by management companies and the response that they take when homeowners are unable to pay. Homeowners have had their property seized because they cannot meet the cost of estate management companies, yet the residents living on the same estates are left powerless to challenge the unfinished and poor quality estates that they are living on. This leads to people echoing the earlier remarks that the current system is skewed towards developers with little access to justice for residents. I'm glad that the Labour government has already pledged to end the fleesehold system. A developer who has not met its promises to homeowners should not be able to profiteer from those very same homeowners. I'm proud that this government is taking the necessary steps to solve our housing crisis. We have a complete shortage of housing of all types. Now, this Labour government is being bold, with a target of 1.5 million homes to the Parliament, reform of leaseholds to end exorbitant ongoing costs for residents to live in their own homes, the current fleesehold system, end in Section 21 and reform in the rental market. And the government has said it intends to bring forward legislation to deal with the commonhold and leasehold issues that are still prevalent in today's housing market and fixing the system, and adoption should be part of this. I'll give way.
John Morris.
Thank you. I just wanted to pick up on some of the points my friends raised around estate adoption, particularly in areas like Medburn, Corbridge and Hexham, my constituency, where I have residents contacting me very regularly concerned about the state of their roads, about the fact that we have unsafe compounds outside of often communal areas. There's some that in the rural communities that I represent is particularly toxic and damages the ongoing faith in the community and damages community spirit. So I hope the Minister can elucidate a little bit in his response as to the importance of adopting these in particularly smaller settlements. Thank you.
I thank my honourable friend for the comments that he's made and absolutely share them, and refer to my earlier comments that this is not just about building homes, it is about building communities. And to do that properly in the way that the Labour government has set out it intends to, we really need to be able to address the issue of unadopted estates. Now, the CMA's report talked about common adoptable standards as one solution that would set out clearly the minimum standard that has to be met for a road to be adoptable, and that there should be mandatory adoption of amenities where the standard is met with only a few limited exceptions. I'd be grateful if the Minister could respond to these suggestions during his response. Certainty could be provided to residents on the timescales within which these adoptable standards will be met, and I know this is something that the Minister has previously talked about. These measures would give residents clarity and would enable developers to be held to account against these timescales and delivery against them. It would strengthen the hand of residents and local authorities to hold developers accountable on putting in place the most basic of infrastructure that residents should be able to expect. And it would address the imbalance between developers and the rights of homeowners when it comes to adoption and delivery of infrastructure. As I and my colleagues in the North East have set out today, residents shouldn't be left on estates for years, paying fees on top of council tax with unfinished infrastructure and a lack of any certainty of delivery long after the developer has left the site. People who've worked hard, saved and bought their own homes deserve better than this. And if we are to deliver the housing that this country needs, to bring communities with us, addressing this issue and the timely delivery of appropriate infrastructure on estates is crucial for getting that buy-in. I know this is something that the Minister will be working on, and I really look forward to their response.
John Slinger?
No.
Not present. Mary Kelly Foyle? Not present. Minister Pennycook.
Thank you, Mr. Sarah. It's a real pleasure to serve with you in the chair. I congratulate my honourable friend, the member for Cramlington and Killingworth, on securing this important debate. Mrs Harris, she's only been in the House for a short time, but my honourable friend has already earned a well-deserved reputation as a hard-working and conscientious member and a doughty champion of the interests of her constituents. I commend her for the impassioned case she just made in support of action to ensure that residential freeholders living on private or mixed tenure estates in her constituency and across the country are better protected from unfair costs, and that the infrastructure and amenities that they rely on are brought up to an appropriate standard. Mrs Harris, the distinct set of problems faced by residential freeholders on private or mixed tenure estates is well known and well understood. These problems include, as my honourable friend has just set out in some detail, excessive or inappropriate charges levied for minimal or even non-existent services, charges that include costly and arbitrary administration fees, charges hiked without adequate justification, and charges levied when residential freeholders are in the process of selling their property. The general lack of transparency and clarity experienced by residential freeholders in respect of how their estate management charges and fees are arrived at and how they break down is compounded by a distinct lack of control experienced by homeowners on estates that have what is known as an embedded management company. Now, comprising around 20% of freehold estates, under this arrangement, the company running the estate is set in the title deeds for the properties and residents have no ability to change it. They therefore lack the ability of homeowners on estates run by resident-led companies, often with the support of managing agents, to exert at least some influence over the level of estate management charges and how funds are spent. During the passage of the Leasehold and Freehold Reform Bill in the last Parliament, I pressed the previous government in my capacity as the Shadow Minister to introduce a right for residents to take over the management of their estates, and we are giving careful consideration now as to the merits of doing so. Mrs Harris, residential freeholders on privately owned and managed estates clearly suffer from inadequate transparency in other unique respects. For example, it would appear to be fairly common for residential freeholders not to be notified of their future liability for charges early in the conveyancing process. Many learn of their exposure only at the point of completion. And even in instances in which residential freeholders are notified about their future liability in good time, many have to confront the fact that their contracts do not specify limits or caps on charges and fees. There's also clearly a distinct problem with management fragmentation on many privately owned estates that have been constructed throughout the country over recent years, with residential freeholders, even on relatively new estates, frequently having to navigate scores of management companies, each levying fees for services in a way that further exacerbates the general lack of transparency and potential for abuse that they face in respect of charges and fees. A related problem which my honourable friend and others have touched upon, experienced by residential freeholders and many of these estates, is the quality and timely delivery of infrastructure and amenities. Historically, Mrs Harris, when a local authority was to adopt an estate, it would set clear standards and provide oversight to ensure amenities were delivered to them. However, the delivery of such amenities is now often left to the developer with limited engagement from local authorities. I've heard countless stories, and we've heard some more today, of how this development is leaving people living in homes on unfinished estates or with facilities which at best are substandard and at worst can be dangerous. And at the root of many of these problems are the falling levels of adoption of amenities on housing estates by local authorities. Now, if honourable members have not seen it, I commend them to go and read the CMA's house building market study published in February, which is the most detailed study that we've come across of this problem. But they detailed how that problem appears to be driven by the discretionary nature of adoption, by house builders' incentives not to pursue adoption in the first place, and by local authority concerns. And I think this has to be acknowledged, because I've often heard, and we did in the last Parliament, calls from the then government simply to put the costs on local authorities to force adoption. But there are concerns among local authorities about the future ongoing costs of maintaining amenities, often delivered to a poor standard in the context of pressures on their resources and finances. But this situation, Ms Harris, is leading to poor outcomes for homeowners, and in some cases potentially serious detriment as a result of exposure to costs, which, as I've set out, are too often opaque and difficult to control, for amenities open to use by the general public and levied, as my honourable friend said, in addition to council tax. The government is clear that the current situation is unfair, unreasonable, and that it must be brought to an end. There's a pressing need to better protect residential freeholders experiencing these problems on existing freehold estates, but also an urgent need to reduce the prevalence of these arrangements, which the CMA estimate represent a significant proportion of new housing supply across the country. Now, Mrs Harris, underpinning many of the issues of concern that have been raised today is the fundamental absence of regulation or oversight of the practices of estate management companies, and the fact that residential freeholders currently do not enjoy statutory rights equivalent to those held by leaseholders. Now, the Leasehold and Freehold Reform Act 2024 took steps to give existing homeowners on these estates additional protections and enable them to hold their estate manager to account for the money they are spending. That Act creates a new statutory regime for homeowners based on the rights that leaseholders currently have. This includes improved transparency over such charges to ensure they are reasonably set, and new rights to challenge them if they are not. Now, bringing these measures into effect will require detailed secondary legislation. Given the considerable amount of detail and thought we need to put into that, we're working at pace, but it's important, and I hope my honourable friends will appreciate this, that we take time to get the detail right. If we introduce that secondary legislation and it has flaws in it, it is your constituents, our constituents, that will suffer from that fact. So it is important that we take the time to get it right and engage with stakeholders, but work is ongoing in that area. But Mrs Harris, those measures in that Leasehold and Freehold Reform Act, we are clear, are not enough. That's why in the government's manifesto, we committed to ending the injustice of leasehold and better protecting residential freeholders against unfair costs. It's why we reiterated in the King's speech that commitment. Now, this is a very complex area of policy, which is why the government intend to consult with homeowners, developers, local authorities, management companies and others so that we can develop meaningful and effective solutions to these problems. The consultation we intend to publish in due course will need to consider a wide range of trade-offs, including cost to homeowners, cost to local authorities, potential impacts on housing supply, and the links to the planning system. So in response directly to the question put by my honourable friend, the member for Stockton North, we will absolutely be considering the recommendations the CMA made and responding, I should add, to their report directly in the interim. But it's one of a number of solutions potentially to this problem. We want to consider everything in the round to make sure we've got the right answer at the point we bring it forward. Mrs Harris, I should say before I conclude that the reforms we intend to make in this area, whatever form they ultimately take, sit alongside our wider plans to bring the feudal system of leasehold to an end. And I think they need to be seen in that context. This is a distinct subset of problems, if you like, on private and mixed tenure estates, but they sit alongside a range of problems experienced by residential leaseholders and freeholders. And that is why the government are going to take steps to enact the remaining Law Commission recommendations around enfranchisement, the right to manage. It's why we're going to take steps to reinvigorate common hold and ensure it is the default tenure going forward, and why we intend to take steps to tackle specific problems such as the injustice of forfeiture and unaffordable, unreasonable ground rents. And I hope to be able to say more on that topic very soon. To conclude, Ms Harris, I'm grateful to my honourable friend and other honourable members for raising their concerns about this issue. We acknowledge it is a problem. I hope they will take my assurances at face value when they say we are working solutions to those problems and we will bring them forward in due course. We want to listen to the experiences of honourable members across the country, and while this is a North East debate, this is very much a problem that affects constituencies in all parts of England. But we are, as I say, committed to taking firm action to end the injustice of leasehold, better protect residential freeholders from those costs, and I look forward to bringing further information to the House to that end. Thank you, Ms Mayor.
The question is that this House has considered estate adoption in the North East. As many of their opinion say aye, of the contrary no, I think the ayes have it. Order, order.